And just a little intro, Cheong is now going to present legal aspects of the marital rape immunity in Singapore.
Okay, I feel that I've spoken already, but I've prepared all this, so you have to give me a chance. Okay, first of all, I'd like to thank the No to Rape campaign and the SMU Law Society for inviting me to this talk. Okay, my purpose today is to tell you a bit about the law, what was the former law on this, and then what is the present law, and then moving forward, what are the possible options for reform. Okay? So I'm going to give you that legal background. Before 1st of February 2008, so before the law was changed by the Penal Code Amendment Act, we had this provision in the Penal Code, which is the criminal law of Singapore, that said that sexual intercourse by a man with his own wife is not rape. So it's a blanket immunity for husbands. The idea dates back to English law, okay, to the idea of women, wives in particular, being the property of the husband. So basically they have no rights. So all that came into our criminal law. An example of how terrible this kind of thinking is this case of public prosecutor and N. Okay? No names, because the name has been withheld. Okay? This case is one example that has come before the courts, where there was a situation of marital rape. Okay? We don't know the true extent of how many people are sexually abused by their husbands. In this case of PP and N, what happened is that the wife moved out to the parents' home because of frequent quarrels between her and the husband. The husband went away on military training overseas, and during a telephone conversation, the wife suggested divorce because of all the marital problems between them. And the husband threatened to kill her if she should leave him. When he came back from his military training, he promised that he would have a peaceful talk with her. So she agreed. She met her. They had a quarrel. He dragged her into his car and drove to the matrimonial home. He stripped her, tied her hands with a bath towel, and gagged her. Then he had sex with her against her will. After that, he demanded that she wear a blouse that he bought for her. Obviously, she would refuse. He slapped her. Okay, for all this, okay, all his acts, he was charged with causing hurt for slapping her, wrongful confinement for tying her up, and criminal intimidation for threatening to kill her. Why was there no charge for rape? Obviously, it's non-consensual sex. But at that time, there was this provision in the Penal Code. It will not be the offense of rape. So he was charged with all the other, you can say, incidental offenses. Okay? What was his sentence? The trial judge gave him a fine of $4,000. $4,000. Okay? They went on appeal. In this case, public prosecutor did a good job. Went on appeal. The former Chief Justice, Cheong at that time, increased the sentence by adding on an imprisonment sentence of 18 months, okay, for all that he did. But it's nothing compared to what he actually did, which is non-consensual sex. The maximum sentence for rape is 20 years. He got 18 months. Okay? So in a sense, what he did is wrong, is criminal, but it's just not considered rape. I think this is the point here. Should it be considered rape? After the Penal Code amendments, which came into effect on 1st of February 2008, this marital immunity has been lifted partially. So instead of a blanket immunity, it will be considered a case of rape between a man, a husband, and a wife in these situations. Okay? For example, if the wife is living apart and there is judgment of divorce, nullity, judicial separation, or they're living apart due to a written separation agreement, etc. Okay? So, in many, many situations, that immunity has now been lifted. it can be a case of rape. Now, how do we see this? It is an improvement. Because before that, it cannot be a case of rape, now it can. So perhaps we should be thankful, right? And also note that this is the case of sexual intercourse by a man or a woman if there is no consent to other sexual acts such as oral sex. There is no immunity at all for husbands. So non-consensual oral sex, let's say he forces the wife to perform oral sex on him by threats, physical threat or whatever, it will be a criminal offense. There is no immunity for forced oral sex. So it's only sexual intercourse where there is a partial immunity. So the glass should be half full in many ways. But there is still some situations left out. If the husband and wife are still living together and the wife has not initiated any legal proceedings for divorce or a protection order, it will not be rape. Of course, it can be all the other things that I talked about, right? Causing her wrongful confinement, criminal intimidation, etc. Okay? But cannot be rape. Second situation, if husband and wife are separated, but wife has not initiated legal proceedings or protection order and also no written separation agreement, also not rape. So if you think back, the case of PP and N, wife had moved out, was living with her parents. She was living separately. But she was only thinking of divorce. She mentioned it on the phone. No legal proceedings yet. So even under the new law, it will not have been a case of rape in the situation of PP and N. So some situations are left out still. So what's happening here? Okay. What are some of the reasons for not removing the marital rape immunity? Okay, two reasons have been given by the government. One is that it will change the marital relationship between husband and wife if we remove that immunity completely. Okay. The husband is not a complete stranger. He is someone that the wife has married. So obviously, there is some affection for this person. Maybe not now, but in the past. There has been previous sexual contact. So there's a sexual history between them. He's not just any stranger. So that special relationship should be considered. If we remove it, treat the husband like any stranger, that seems wrong. Right? So that's one argument. Okay, I have some sympathy for that argument. I think it will change the marital relationship, right, if we remove that immunity completely. But I agree with Benny that I think the marital relationship will be changed for the better, not for the worse. Okay? The second reason given by the government is that the wife has to signal that consent is withdrawn very clearly. Otherwise, husbands will not know. They think that if you get married, you can have sex on demand. Right? So if you move out and apply for protection order, it's very clear. He will say, aha, he'll wake up. I mean, what can I say about that argument, right? I think husbands should be given greater credit now. I mean, not all the time, but maybe in this. Okay?